and welcome everybody to the Restructuring and Insolvency panel. I'm glad to introduce you here to the three panelists with me here today. We've got Sotiris Foteas of Partner AK Law Firm, who is a co-lead of litigation and restructuring department in that firm. Then we have Anthi A.Floropoulou, who is a managing partner at A.Floropoulou Law Firm. And finally, on my left, we have Dimitrios Kanellopoulos, who is head of legal at Attica and an expert in securitizations. So thank you. Well, finally, myself, Michele Pedrotti. I'm a director in Alvarez & Marsal in the portfolio advisory group team. So yeah, thank you everybody for being here today. I'd like to set the scene perhaps, and maybe Anthi, you can help me with that, in terms of setting the framework for the latest legislative changes that happened in 2020 with the so-called second chance law. Could you please walk us through what's happened and what has changed and what you're seeing in practice?
Yes, thank you for this opportunity, Michele, and I will try to expose in a nutshell the basic changes of the new law, and also share with you my experience in restructuring and insolvency. The new insolvency code was established in 2020, was put into force in 2021, and actually has now started to be put to the test. And the reason for this is that during the COVID pandemic, a great financial support was provided to the companies, and in this way the ceasement of payment and the financial problems were postponed. But now we are coming to this point that the new law will going to be tested, and also in terms of restructuring, and also in terms of insolvency. The new law actually is a unified code by which the restructuring and the insolvency has common provisions for consumers and merchants. As far as the restructuring methods are concerned, there is an updated extrajudicial mechanism, the so-called OCW mechanism, that gives the opportunity to the debtors to negotiate with exclusively with the Greek state, the social funds, social security funds, and the bank institutions, and achieve a debt settlement. This kind of restructuring is ideal for simple debt settlements with a relatively low, let's say, haircut of the debts and a simple rescheduling of the payments, of the installments. If the company has more other creditors and not the three I mentioned, Greek state, social security funds, and bank institutions, then this kind of restructuring is not appropriate. And if also the company needs a more complex restructuring, then also this is not appropriate. Despite the expectations and the numbers of petitions that were already filed, and the fact that they were increased in the last months, we could say that the successful restructurings through this procedure are extremely and remain extremely low. The reason for that is that first, the banks and the creditors are not very familiar to this method because this is a automated system, and this negotiation is being made through digital platform. Actually, the creditors prefer to negotiate face-to-face with the debtors. We also noticed that although the debtors start and file petitions for OCW procedure, then actually they do it to investigate the quality and quantity of their debts in order then to file for a bankruptcy. The other method that is introduced by the new law is the rehabilitation agreement. Actually, the rehabilitation agreement was also a part of the previous law, and but now some improvements have been made. The basic provisions have been maintained. The rehabilitation agreement is an agreement that is ratified by the court, and this is its greatest advantage. The fact that is ratified by a judge and is binding for all creditors of the companies, of the distressed companies. This safety that the judge decision is giving is very important also for investors, and that's why it is better for an investor to seek for this restructuring method. If the investors decide to take over a business activity through a transfer of business, and to take also a part of all the assets and a part of the liabilities, and run this activity through a new company, and not the old distressed company. In this case, this method is more preferable. The biggest restructurings in our country's legal past have been made through this method, and they were really successful. This is meant to be, it was proven to be a very successful method. This is for the restructuring. And now we have to say that the biggest change of the new insolvency code is in the insolvency proceedings. Eligibility to insolvency, to bankruptcy, is now given not only to merchants but also to consumers. And both of them can be discharged within 3 years after the bankruptcy date. During these 3 years, they will give a part of their income if it exceeds the reasonable living expenses, and then they will be discharged. So this is the reason why the new law is called the second chance law. The insolvency is supported digitally, and the petitions are filed electronically. There is an insolvency e-register where anybody, any interested party can be informed of the proceedings. And legislator actually tried to provide solutions to accelerate the insolvencies, to do many things without court's contribution. The court hearing is not necessary except if the creditors oppose. So in this way, and by accelerating the liquidation of the assets, because a part of the liquidation, when the liquidation is being held by auction, by e-auction, and we go to a second round, then the initial price is decreasing automatically. So by all these ways, the legislator tried to accelerate the insolvency and to finalize this period of insolvency. So after 3 years, the bankrupt can make a fresh new start.
Okay, thank you. Thank you very much. Something that strikes me about what you just discussed is about the use of technology. It seems like there is an effort by the government and institutions to introduce technology to the various processes. Do you have maybe a couple of words, a couple of thoughts about how is the take-up going? How are users taking the technology, and how is also the administration able to adopt and make use of those technologies? Question for you or for anybody else on the panel.
Everybody is trying to do its best. The problem is that the petitions are filed at the electronic platform, but then the personnel of the courts has to update, and there is a problem, a serious problem there, because the personnel is not trained to this platform. So we're facing delays because of that. If this could be better, then I think the times would also be much better.
Yeah, so time will tell if
Yes.
These are just teething problems or if it is more like a fundamental issue.
Yeah.
May I?
And yes, of course.
It is obvious that we have an insolvency code for something like 100 years in Greece. And now we come into a situation where we have to change the way that we see what is insolvency. Not only the courts, not only the state, not only the parties, not only the servicers, not only the debtors, everyone has to see what is insolvency. When the insolvency procedures were taken in the Greek legal regime, it was more or less a situation where the bankruptcy was a way for the debtor to take back, to liquidate the assets of the debtor, and so as to receive some of his debts back. But today the insolvency code does not focus so much, at least not only, not so much, I will say not only to the bank or to the lender itself, but also focuses to the debtor, because this is the reason it's called the second chance law. So we have to at least have a waiver period. Say 1 year will be adequate so as everybody to adapt to the new situation, to see how it works, and then we'll see if it is successful or not, and if the Greek system, the Greek legal system is ready to support the new structure, the new framework.
Yeah, it's very early days, and plus there's been the pandemic in the meantime, so there was already a backlog. That means that the courts were already overwhelmed. Well, maybe stepping back a little bit from the technicalities, we'll get back to some of the technicalities later on. But maybe I'd like to introduce a little bit of an element of the current situation. Obviously, the COVID pandemic is hopefully behind us, but still some of the effects are presumably perceived in the economy. And obviously, we've got the latest crisis with the war in Ukraine and the repercussions, indirect repercussions on energy prices, commodity prices, etc., etc. Maybe I'd like to get your view, Dimitrios, on what are you seeing from the banking system, in the banking system, and how is this reflecting in your books?
Okay, thank you. First of all, I would like to thank you, DTC Financial Group, for this great chance to be a part of this panel. I would like to first introduce myself. My name is Dimitrios Kanellopoulos. I am the head of legal of Attica Bank. And why am I doing this? Because Attica Bank is a case scenario in a way. It was the first bank, although it is the smaller of the Greek banks. It's the first one that has started the securitizations according to the securitization law. We have an experience of 4 to 5 years of securitizations, not only on the primary market, but also on the secondary market. We have restructured securitizations, and we had a direct hit from the crisis of 2008, a direct hit from the Greek bond crisis, and now the last years we have also one more hit after the restructuring, which is quite important, from the COVID crisis and the Ukraine war effects. So what is the aftermath of all these situations? The aftermath for a bank is that you have always to be dynamic. You cannot settle, you cannot even think that now you have a stable framework. You always have to be together with your clients and together with the other parties in the financial market, so as to be pretty sure that both the bank and the system, but also the portfolios that you are servicing are stable, and most important, that the business plans are bringing the revenues promised. So what we can see, first about COVID. During the COVID period, the government really took a lot of measures, and there was a significant state aid towards the debtors and towards the market, so as not to have a new generation of NPEs and NPLs. Was it successful? It seems that it was. The statistics now show that we do not have and we do not expect something quite extraordinary from the loans that have been either restructured or settled or had installments postponed during the COVID era and because of the COVID. Also, there was a significant liquidity injection during this period through programs either from the development bank or from the state itself, or through guarantees. And this is a situation that kept the market steady so as to move ahead. So if it was only the COVID, I would say that things is quite not out of business, on business. Now we have the second, the other situation that came recently. To be very sincere and honest, we do not, as the banking system is estimating the effect of the Ukraine war and the problems in the financial economy and the raising prices. Our bank does not have so much risk on Ukraine itself, but it's quite. I would say it's not correct to focus only if you have risk placement on a market or not, because the consequences of the war are inevitably affecting all of your clients and all of the market chain. Do we expect another kind of liquidity injection from the state, except of some specific programs, which is rather not programs for liquidity, but more infrastructural actions. The previous panel, I think, referred more or less to such actions. Cannot be described that we are expecting something from the state itself. So the banks and the servicers, because we should not leave the services out of the picture, have a big role to play, and the big role is to find all the solutions necessary to keep the clients bankable. The big question is, how do you keep someone bankable, or how do you make someone bankable? And now we have to go back to the roots. Back in 2015, 2014, when we had the necessity to have services. Why did the system went on and created what we call servicers? And if we make the servicers of today institutions as the banks were 10 or 15 years ago, then the problem will be here in 5 years, 10 years, 15 years, once more. We are going to solve nothing. This is as simple as that. The only real point of view from the banks and the services side is to acknowledge that the clients, and in Greece it's a specific amount of clients, these are the 50,000 SMEs that we know they are there. It's not 1 million, it's not 2 million, it's a specific amount of companies that work, and all of them are cooperating with most of the banks. Of course, we have a main one, but not necessarily only one. So what the banks and what the services should do? First of all, the aspect is to keep the clients and the debtors bankable. So we have to have out of the self restructuring proposals, needing less time, needing less decisions, needing a very efficient decision-making procedure. This is also the same for the servicers. The servicers, if they get stuck on procedures that they take time and they take a lot of approvals so as to move forward, then the bottleneck effect that we faced in 2015 is going to stay here as it was, with new NPLs, with new NPEs, and the problem just being brought back into time. Our bank and our staff, what we are trying to do is to have an efficient early warning system. This is what will separate the debtors that are viable and the debtors that, although they may have some difficulties, they can stay viable and not transfer these accounts and not characterize these accounts as non-performing loans. Is it something that can be done with strict rules? No, it cannot be done with strict rules. I had some data that we had some specific data, and what is this line between banking and servicing, let's say, framework, with when we have 80%, when we keep 20% of the biggest tickets within the bank, that represents something like 80% of the GBV of the loans. That means that as a bank, you usually refer to incapacity to handle a big amount of accounts, but in the reality, you can lower these accounts you have to service in, let's say, 20% of the total. At the same time, simultaneously, you are keeping 80% of the GBV within your control. Do you want to keep this control? This is another question for another panel. I will not enter into this. What we keep as, let's say, the final answer to what we do with COVID or with Ukraine crisis is that you always has to be above the account. You always have to be ready for an early warning system when you see and with specific criteria. And you have also have to discuss every day with the services that support your nodes to have solutions and credit policies to keep the clients bankable. And this is, Anthi, okay, she's not here, but I always disagree with people that say that perhaps the liquidation and the insolvency procedures are a state-of-the-art solutions. When you need 3 years to give the second chance to someone, that means that we should prefer an amicable, informal solution on a bilateral or multilateral basis. And when we reach the big tickets, we know that we are going to find a solution, either through habilitation procedures or through courts or whatever. The big tickets are always more easy to find a solution. But we have thousands and hundreds of thousands of SMEs or retail loans that we cannot afford, the banks or the servicer, to wait for 3 years for the insolvency code to get enforced.
Yeah, indeed. I mean, the amicable solution is almost always preferable, as it saves everybody time and effort, and when it's possible to achieve it, it's always a very good result. There's, as you mentioned, there's a number of difficulties in making this happen, and it's potentially even more difficult once the loans have already been transferred into securitization, and we can maybe touch on this topic later on. But thanks for that. And maybe to go back to the more technical aspects of the insolvency and restructuring reform, maybe if Sotiris, you could walk us through some of the challenges and some of the mitigating factor of the new reform.
Thank you, Michele. Thank you for this kind invitation. It's a pleasure and privilege to participate in this very interesting panel and addressing this very special audience. My dear colleagues have insightfully set the general context of the Greek NPL market during this transitional post-COVID era, and I agree on their main findings. General conditions may lead to the gradual emergence of a new generation of NPLs. New structural concepts are necessary to prevent such evolution. The recent amendments over the last 2 years in the legal framework of the Insolvency Code and the enforcement, the Code of Civil Procedure regarding the enforcement have indeed contributed to the simplification of the procedures in favor of business-friendly solutions and business-oriented decisions. However, such conclusion still remains at a theoretical level and is subject to an empirical, to a practical verification in the course of the facts and the case law. So my specific input to this panel would be to trace and further discuss some additional points deriving from the amended legal framework, which may be relevant to the assessment, the increasement or the mitigation of the risk. First parameter, some new statutory concepts under the new pieces of legislation. Anthi gave us earlier a very brief and representative panorama of the innovations, and I will not revert on that. Just a few comments to add. Point one, we have a partial return to the regime of stay of the proceedings, within the context of the enforcement as a debtor's defense to the attack of the creditor. The recent section 938 of the Greek Code of Civil Procedure reintroduces some defense facilities of the debtor that were removed back in 2015. And although the courts have maintained these lines of defense through indirect means and indirect concepts of law, it is important to note that, once again, an explicit provision reinstates the ancient regime. So it is not yet clear whether this will result in further delays or not. Point two, the replacement of the special administration regime as provided for under the law 4307 enacted back in 2014 by a similar procedure of the Articles 158 of the new Insolvency Code that provides for the option of a liquidation en bloc, a liquidation of business units instead of a liquidation per assets, which is now provided as a specific pathway within the context of the bankruptcy. So the law quits the fragmented, the piecemeal approach and aims at the unification of the whole regime. It is true that the new Insolvency Code promotes the concept of such asset deals as appropriate to ensure the survival of business lines as a whole and the optimization of their value. So this system is not yet tested, but our estimation is that it is structured towards the right direction. And point three, as Anthi mentioned before, the facilitation of the requirements for the ratification of a rehabilitation agreement in terms of the competent bodies, the necessary alternative and cross majorities, and other procedural parameters. Apart from the technical simplification of the relevant provisions, I believe that the placement under the rehabilitation regime is also facilitated from a material point of view, and this is very important. Second parameter is some recent findings in the case law of the Greek courts. Point one could be that we observe a contestation of or a tendency of limitation of the procedural powers which are conferred to the servicers in the context of the enforcement. Recent case law puts at stake the scope of their authorization to act in the name and on behalf of the debt owner by precluding several procedural actions. And point two is that we can observe an increased tendency of the Greek courts to consider the pandemics as an event of force majeure in the existing contracts, especially in cases to which the law did not intervene in order to regulate them directly. So I cannot preclude that a relevant tendency, a relevant practice can be developed in the case of the Ukrainian crisis as well, especially regarding lines of business that are directly affected by the relevant factual background of the war. So these may have a dual normative impact on existing contracts. First, it may be invoked as a legitimate basis for the granting of interim protection of the debtor within the context of an injunction procedure or within the context of the interim measures framework. Second, and more important, is that it may also be considered as a fact readjusting the material terms, the substantive terms, the substantive parameters of the debt, such as the amount due, the time and the dates of the arranged installments or the interest rates. And my feeling is that the number of lawsuits from debtors, the number of civil actions by debtors aiming and seeking for such readjustment, for the remaking and the corrective rewriting of the contractual terms is rather considerable. I would say that we are in front of a new wave of lawsuits that tend to become a general practice. So under these circumstances, my concluding remarks would be the following. Yes, Greece may be considered as a case of opportunities in the NPL market. Yes, the modernization of the insolvency framework is a factor mitigating the risk. However, the Greek legal system is far enough from being considered as a success story in terms of time and clarity, and the new concepts do provide a solution, but are not yet tested at the level of their practical applicability. So the procedural risk of delays and other concepts of law must be regarded as a special dimension of the overall risk that should not be neglected and somehow reflect the particularity of the Greek legal order and the particularity of the Greek market of NPLs.
Understood. Thank you very much. Just checking here how much time we have. We are out of time already. Okay, maybe just some closing remarks then. Maybe just my question would be, do we have any view of how long you think we will have to test this new regime before we can say, yeah, it is working or not, and also a rough estimate of how much in terms of time it could reduce the timing that it's going to take to resolve cases, if you have any, high-level idea.
Πόσο να περιμένουμε.
Dimitrios?
Εσύ πρώτα.
Okay. Well, I would say that a period of 1 or 2 years is necessary to test the whole new system. The problem here is in Greece that the restructuring culture is not very familiar for debtors, and that creditors and debtors haven't really understand that there is a need to collaborate in order to get to a real restructuring. this is the one problem, and the other is the lack of financing that was clearly mentioned in the previous panels. I would only like to add that there is, according to the regulatory network, legal framework of Bank of Greece, the bank institutions that securitized or sold their distressed loans are prohibited to refinance them. So this is the reason for which we should seek for another refinancing method.
Yeah, that's one theme that will come out many times before today, and probably time for another panel to discuss just this point, which is quite fundamental. If anybody hasn't got any final remarks.
Just a final comment is that we understand that the insolvency code is a big step ahead, but we also have to have in mind that the timelines of this insolvency code is not ideal, and mainly the services that banks cannot afford to give solution based on auctions or on insolvency code proceedings. It was referred before that the secondary market is quite vivid lately, not only on note holders and on loans itself, but also on servicers. The servicers should start to specialize on specific loan segments, so as to have better policies and to bring more revenues back. And we understand that this is the only possible, flexible and quite successful approach for the next 1 or 2 years. If otherwise, we're going to keep running on the same style for 1 or 2 years, and then from 2025, we'll see the first results of the insolvency code. Today, as it stands, the insolvency code is for this kind of debtors that they do not have any other assets, that they do not have anything other to lose, that they are not afraid of auction procedures, so they want to be bankable again. We respect this. This is something that should happen. We will need to bring more clients into the service, more possibly the companies to be bankable again. But this is not servicing of MPEs. This is creating new material and new market players. This is a comment, and I would like to thank you. I would like to thank DTC.
Thank you. Thank you very much. Thank you, Sotiris, Anthi, and Dimitrios. Thank you very much for your time.